Welcome to another episode of False Claims Act Insights. I'm your host, Jonathan Porter. Healthcare transactions are a huge potential source of risk in the False Claims Act world. In a past episode, we talked about the Stark Law and how healthcare providers can find themselves in a world of enforcement trouble by letting the volume or value of referrals seep into business decisions. And in a September episode, we talked with my friend Jim Mooney, who runs the Georgia Medicaid Fraud Division, about the anti-kickback statute and how that statute can have disastrous consequences for those who put a price tag on referrals and a host of other things that Congress has labeled as illegal conduct. But when flashy DOJ press releases start flying around, we at Husch Blackwell hear a lot from our healthcare clients who want to know whether their business decisions are somehow setting them up for enforcement disaster. How do we grow without crossing lines? How do we discuss basic business realities without those discussions touching on potential value of referral sources? A recent Stark-based False Claims Act lawsuit against a Tennessee and North Carolina health system shows the consequences of crossing that line. And so we're going to talk about that case and how to maintain compliance in healthcare transactions today on the podcast. Joining me to talk about healthcare transactions is my friend and law partner, Hal Katz. Hal is a giant in healthcare. He's a former chair of the ABA Health Law section. He's a former chair of the State Bar of Texas's Health Law section. And those things are good, but what I really want to credit Hal with is how he serves his clients. I met many of Hal's clients over the past 2 years at conferences and the like, and Hal is more than a lawyer to his clients. He's a part of their team. It's a great trait that I've tried to replicate, and most germane to today's conversation, Hal is a sought-after healthcare deal lawyer. And so I'm excited to talk with Hal about this topic. And so coming to your digital airwaves from the great city of Austin, Texas, is my friend, Hal Katz. So Hal, thanks for coming on the podcast and telling our listeners about how to avoid False Claims Act liability when discussing financial issues in healthcare.
Jonathan Porter, you are incredibly kind, and it is a great privilege to be on your podcast. Thank you very much for that introduction and for being with you today. I'm a huge fan of yours as well. I've learned so much from you and always feel incredibly fortunate to have you and your expertise when needed. Thank you so much.
Thanks, Hal. You're too kind. So, Hal, I mentioned a minute ago that we've talked about Stark and kickbacks before on this podcast, but rather than just telling our listeners to go back and listen to those episodes, they might not do that. So it might be more helpful if we give a short overview of those laws so that our listeners understand exactly why this is an issue in the first place. So, Hal, can you give us a brief overview of the Stark Law and the anti-kickback statute? Really, what are the most important things about those laws for those in the healthcare and life sciences industries to understand?
Sure, Jonathan. It may be helpful, but it will be a little painful to, first of all, being familiar with the Stark Law and the anti-kickback statute are critical to ensuring compliance in healthcare, especially when physicians are involved. We'll start with the Stark Law, which specifically prohibits physicians from referring patients for designated health services. Now, DHS is a term of art, as you know, as others probably know. It's defined to include specific services, not everything. And it's those services payable by Medicare to entities they have a financial relationship with, unless there's a specific exception. And that's really important. That means if there's not a specific exception, it's going to violate the Stark Law if the Stark Law applies. The key element of compliance here is ensuring that any financial transaction with a physician is at fair market value and that it's commercially reasonable without taking into account the volume or value of referrals. Then we've got the anti-kickback statute, AKS. It goes a step further. It's not just applicable to physicians, it's applicable to everybody. It prohibits any form of remuneration in exchange for referrals or inducing business generation. It's designed to keep financial incentives from impacting medical decision-making, trying to ensure that patients get the care they need objectively. Their needs are top priority. And any arrangement that appears to link value of a business to referral patterns could trigger an AKS violation. And you've shared that leads to both potential criminal and civil penalties. So together, these laws are designed to ensure healthcare providers remain focused on patient care rather being influenced by potential financial gain from referrals. Hope that helps frame our discussion.
Yeah, I think it does, Hal. I appreciate that overview. I know it's hard to start a podcast episode with talking about, the basics of Stark and AKS, but it really is important for understanding why is it that we're going to talk about these issues today. And so the big thing to me about Stark is that it's a strict liability statute. So you don't have to have any particular mindset in order to violate it. And that's different from AKS. The Supreme Court earlier this month denied cert in a case, in a Second Circuit opinion that said that in order for someone to bring a False Claims Act case premised on the anti-kickback statute, you've got to show that the person knew that what they were doing was unlawful. You've got to have plausible allegations that they knew what they were doing was wrong. So that's the big disconnect, just for me to call out up front, is Stark law, you don't have to have any particular mindset to violate it. Any kickback statute, you have to violate it willfully. You have to know that what you're doing is wrong. And that's a pretty important distinction. I want to call that out for our conversation right now because I think it's important. So Hal, last month, you and I wrote an article that lays out what we're talking about today. And in our article, we talked about these concepts being important in the context of transactions. Help our listeners understand what that means. In your experience, Hal, what kinds of transactions might we see Stark or AKS risk? Give us some examples.
Sure, Jonathan. It's what many of us have been reading about in the news. The trend in healthcare is around consolidation, around growth, vertical and horizontal integration. We'll start with selling a medical practice to a private equity buyer or a strategic buyer. In these deals, we have physicians who are trying to maximize the value of their practice while the buyer's trying to get a purchase price that will ensure that they get a nice return on their investment over time. Here, the risk is the purchase price could be viewed as compensation for future referrals if the buyer is anticipating that those referrals are going to drive revenue post-acquisition. So that's one example. Another example would be selling a portion of a surgery center to a national surgery center operator. So it's either a group of physicians or maybe it's non-physicians who own the surgery center. And there's a publicly traded surgery center operator that is looking to grow through acquisition, but wants to keep the current operator in the game. So here we've got physicians, also often an owner, and they practice at the surgery center. They hold that equity, as mentioned. As with the selling medical practice mentioned previously, both the physician owners and the investor are motivated to negotiate a competitive purchase price. However, the sale price is influenced by physicians' expected future referrals. This will definitely raise concerns under AKS. A third example of the kind of transactions that I'm working on these days are the creation of a joint venture where a medical practice and a hospital come together to form a service line management company. Here, the joint venture presents additional risks, particularly when we have these physicians as owners. These arrangements often result in the physicians having a financial benefit because they're going to be owners of the management company. The management company manages the hospital service line. The hospital pays the management company for those services, and the physicians are going to get some kind of distribution for that. So their capital contribution and that management fee under that management agreement must be consistent with fair market value and commercial reasonableness. So those are three examples, Jonathan, as to where these issues are arising.
Thanks, Hal. Those examples are really helpful. I'm sure our listeners appreciated hearing exactly what type of situations we're seeing this risk analysis play out. So, Hal, to me, what's tough about these laws is that they're really pushing against what would happen in a normal market economy. In other industries, lots of companies acquire smaller companies because they see business opportunities in adding the smaller companies, customers, for example. So for example, Google bought YouTube, not just for YouTube's individual profitability, but also because YouTube helps Google cross-sell other products. It helps Google get better at targeted advertising, all sorts of other stuff. There was value beyond YouTube's P&L in isolation. But in healthcare, there's real risk in paying for things that go beyond a target company's discrete profitability. We see this in the Justice Department's False Claims Act complaint filed against Erlanger Health a couple of months ago, where DOJ says that Erlanger was paying physicians for the value of their referrals. In the DOJ's complaint itself, DOJ cites to an interview that an Erlanger senior executive gave to Modern Healthcare. And the quote from the article is that Erlanger's, quote, finances improved as a result of hiring more physicians because most of the new doctors add revenue through increased referrals, especially if they're local and bring an existing patient base with them, unquote. How? I think if we have CFOs for companies outside of the healthcare industry listening to this, they're nodding their heads saying, yeah, that makes sense. Because there really is value brought in the way that the Erlanger executive mentioned. But that's a big problem in healthcare, as evidenced by the fact that we're quoting this from a DOJ False Claims Act complaint. So how? What are healthcare providers to do here? How can healthcare providers do business without crossing any lines, as Erlanger may have done here?
I know it is so frustrating to people within the healthcare industry, be it physicians operating their medical practice or owners of a surgery center or senior executives within those companies, as well as within the hospitals. There is a double standard. There's one standard for the healthcare industry, and there's another standard for all other industries. And the first thing to do is maybe get a little therapy to let out some of the anger and, let that go. And then the second thing is, or the second step is to learn what the requirements are in healthcare for valuing a purchase or an investment in a healthcare business. Or when looking to sell your business, you need to get up to speed on how you can calculate the purchase price for selling your business or a piece of your business. You know too well how regulated this industry is, how high the risks are if you don't do this properly, and there's no way around these laws. So understanding these laws will be incredibly important if you want to pursue either a sale or a purchase of one of these businesses. That's the first step. The second step is you'll get to it is understanding that expected volume or value of referrals cannot be calculated in the purchase price. From the seller's perspective, the valuation should be based on current revenue streams, operational efficiencies, market position, without factoring the potential future referrals. This needs to be documented. The seller doesn't usually engage a valuator. That's something usually the buyer is going to do. But the more they can be prepared for what the seller is going to be looking at and needing in calculating the purchase price and what their valuator is going to be expecting to provide a fair market value purchase price, the smoother this process is going to go. And the less risk there will be some avoidable mistakes along the way. I know we're going to get to it in a little bit, but there can be some expressions of frustration early on in the negotiating process of why a seller doesn't think the purchase price is reasonable. You're not considering all these things. And the buyer knows that they can't consider all these things that the seller may have just put in an email or in a text message that maybe a regulator or someone concerned about the transaction could misinterpret and use against the parties to the transaction down the road. So from the buyer's perspective, as I mentioned, while they're going to need to engage a evaluator to help in determining what the right purchase price can be for this, the good news is there can be future growth built into the purchase price calculation, but there are some specific requirements around how that is determined. It's not going to be based on what these individual physicians are going to be referring, and those individual physicians will not be directly rewarded for their individual referrals. The buyer is going to base this on those objective business factors, operational improvements, service expansion, market penetration, things not tied to any anticipated referrals from those existing referral sources, be it physicians or otherwise. They'll also go through this extensive quality of earnings review that will further help support the purchase price by saying this is our, stable seller and their financial performance, both past and projected, and that will support any scrutiny or avoid a regulator or someone else not happy about the transaction spending too much time challenging the transaction, because the buyer and therefore the seller will have a well-supported and documented valuation of the business.
Thanks, Hal. Yeah, that's really helpful. So yeah, totally agree. Find someone who does this. There's a big market out there of people who know how to help you with fair market value. They know what factors to calculate in and they know what factors to calculate out. And so don't wing this. I think most experienced people in the healthcare industry know not to wing it. So, but that's good. But no, I appreciate how you also focusing on the need to document what you're doing as the person who comes in and cleans up this for people who do it wrong. Let me tell you how important it is to document your valuation process. It's super critical. I need a document to take to the Justice Department or to a, potential whistleblower and say, this is how we got to the number. Here's how you can know that no referral-based considerations influenced the transaction. And that's how we show. You got to document what you're doing. That's critical. And Hal, thanks for telling our listeners how important that is, because it is. So Hal, I think a lot of sophisticated healthcare providers understand where the lines are, what they can pay for and what they cannot, and why that line exists. But even when you follow the right fair market value processes, there's always the chance that someone comes along and second guesses you. There's always the chance that someone within your organization says the wrong thing, even when the organization tried very hard to do the right thing. And that may have happened in the Erlanger case. Erlanger is a large, sophisticated health system. It's possible they did the right thing, but one person gave an interview saying the wrong thing. So Hal, what are healthcare providers to do here? What are some of the best practices for communicating both internally and externally in a way that reinforces compliance?
Jonathan, on the provider side, it's so important to be formal, intentional with communications. And it starts with putting together a deal team. Regardless of the kind of transaction, especially if it's a larger transaction, there needs to be a formal team appointed who will be responsible for all aspects of the transaction. And that includes communications. It will include the early stages of getting ready to go to market and how things are communicated internally within the team, more broadly internally within the organization, and then outside the organization, be it with a broker, if that's the course or the strategy the provider decides to use, engaging a broker to help go to market, to negotiating the LOI, going through the due diligence process, and then keeping everybody up to date. Therefore, the deal team needs to be the one coordinating all of that. They need to be the one who appoints the person who will answer questions from internally within the organization, who will update the larger group. And there needs to be an understanding that those communications need to be in formal channels. Email can be a formal channel. Text messaging is not a formal channel. Of course, social media is not a formal channel. One-on-one conversations throughout the organization is not considered a formal channel. So emails, reports, partner meetings, committee meetings, that's what I mean by formal communications. And when they're talking about financial performance or key parts of the deal, that's especially sensitive information, and being very thoughtful on how those communications could be misinterpreted should always be on people's minds. Physicians, senior management, these people are very busy. They are managing their day job in addition to being involved on this team. They are operating on patients. They are taking care of patient needs, which are very demanding. And so when it comes to updates, questions on the deal, it's tempting to give short, quick answers. We're trying to get as much as we can for that new location, or we're trying to get, Dr. So-and-so happy, and we're going to try to get him more money. those kind of communications can be easily misinterpreted. So we really want to be formal with that communication. And this is an issue for not just the sellers, but for the buyers. But historically, it's been more challenging and more of an issue on the seller side. But related to that, when the buyer has a team of its own and the buyer has team members reaching out to different representatives within the seller's organization that may not be on the designated team, there needs to be an understanding that those communications need to be redirected to the designated people. As hard as that is, as tempting as it is to get that real-time information and get the behind-the-scenes update, those communications really need to be redirected.
Thanks, Hal. Yeah, so communications are a big deal in my world. So it's amazing how people don't understand when they're writing emails, how important that email could be down the line. There's such a small bit that is needed for a whistleblower or the Justice Department to get over the threshold and get to a jury on one of these cases. If someone's going to say that you've done something wrong in a transaction, all they need is just like an email that can be taken potentially out of context in order to get from no jury to a jury, and for you to go from a manageable situation to a really bad situation. So I'm just sort of stunned. The emails that I saw when I was at DOJ, where people are typing away late at night or whenever from their iPad saying, here's what we're going to do. And it just creates this big issue. And the problem with emails or text messages is there is context behind it that gets lost over time. I've got a lot of clients who aren't doing anything wrong, but they are writing emails, and you could view it in one way or you could view it another way. And it's hard to regain that context. So I think one of the most important things in any deal is convincing the people around you, hey, we're not doing anything wrong, but let's also be smart about the way that we are communicating what we're doing, because context is important. And when you lose that context, there could be disaster. So Hal, thanks for telling our listeners about that and emphasizing how important that is. So Hal, we've been talking mostly about these issues in the context of deals, transactions, but these concepts, they apply in other settings too. There are all types of ventures that healthcare organizations may choose to support. For example, a few decades ago, payors started pushing more and more surgeries out of hospitals and into ambulatory surgery centers. And so groups of physicians have responded to payers by building and operating ambulatory surgery centers. Those are business endeavors, and they only work if you can keep the lights on. That means that there are financial considerations. But if you're treating Medicare patients or Medicaid patients, there are lines you cannot cross when discussing those financial considerations. And so Hal, close us out by telling our listeners how those running, in our example, surgery centers can keep the lights on without crossing any compliance lines.
Jonathan, it's tough. It's tough whether it's a surgery center and the physicians happen to be the owners of the surgery center, or even non-physicians are owners of the surgery center and they're relying upon physicians to bring cases to the surgery center in order to cover the costs associated with keeping the surgery center open, or having the best anesthesia staff, or having the latest operating room equipment, the C-arm, the MRI, having physical therapy available within the surgery center. But that is the same issue within a medical group, a physician medical group that is also trying to be competitive. It is trying to have all the services necessary to meet the patient's needs, so the patient doesn't have to go just to them for services and then go across town for lab work or diagnostic work or physical therapy. How do the medical groups add additional services, incur those expenses if they aren't able to ensure that they're going to have the revenue to cover those costs? So, that is the challenge. Here too, it is very important that communications be thoughtful, be formal, and come from a management team and not indirectly from the management team through physicians who might know what the issue is. There might be a surgeon, for example, in the surgery center who really wants a piece of equipment, but understands that the surgery center isn't going to purchase the equipment unless the surgery center can have some projections on the case volumes for that kind of procedure on a monthly basis. So these informal communications between a physician and another physician who's trying to get this equipment purchased can be misinterpreted. You've got to bring all your cases here so we can provide the services, and we're going to make more money, as owners of the surgery center if we're able to provide these additional services. So the information around the services provided by the surgery center and the desired services to be added should be included in a business plan. The business plan is adopted by the governing board after making a recommendation from the management team. The management team, in putting together that recommendation, can interview the current referring providers to understand their case volumes, their projections. But this is a really intentional and well-documented process to understand the current needs in the market and potential future growth, but based in the community and the standard of care. That can be documented. Then I think we have low risk when the organization starts tracking expenses and cases and revenues and puts out general reports on how the expenses, how the revenue, how the financials of the service line or the overall surgery center or the facility or the practice are doing, to encourage people or to utilize services that are available within the organization if medically necessary and the patient chooses that as their site of service. It's really about education. It's really about understanding what services are available. And I'd be really interested, Jonathan, in your thoughts on where that line is in how to promote a service, promote capacity, communicate capacity within the surgery center or whatever facility we're talking about without it being perceived that physicians are being encouraged to refer for a kickback.
Yeah, Hal, thanks for throwing the hard question back at me. I don't think there's a really good answer. It's really tough because things like surgery centers or joint ventures, they only work if you have business. The payers have caused a lot of shift in healthcare, and you're not seeing things in the hospital anymore. You're seeing physicians need to perform things in surgery centers a lot more. You're seeing a lot of alternatives to hospitalization. Those are things largely caused by payers. Physicians are responding and health systems are responding, but it's hard because you've got to keep the lights on. I mean, physicians are not running charities. They're not going to invest in something that's going to be a, dumb investment. And so it's hard. You've got to talk about what our capacity is at the surgery center. You've got to talk about the economic realities of it. But I totally agree with you, Hal. You've got to do it in a smart way where you're not crossing lines and saying, hey, when you invested in this, you agreed to do 17 procedures a month and you've only been doing 2. It's hard for you to talk about the business realities, but being mindful of the fact that this could be second guessed. This could be seen as putting undue pressure on people to do procedures that they otherwise wouldn't choose to do. It's hard. It really is. I feel for those that I talk with in the healthcare industry about these issues, because I don't think anyone's going into these situations saying, let's go get a bunch of money that we're not entitled to. How do we run this in a wise way, in a prudent way? And it's really hard, Hal. So I'm glad that there are people like you who are guiding clients through these hard decisions. And I just get to come in on the back end if things go all wrong.
That's scary for me. I'm on the front end, you're on the back end.
Yeah. But Hal, I really want to thank you for coming on the podcast. This really is a tough enforcement landscape. Like we said at the beginning, the Stark Law is a strict liability statute. And so that interview we talked about in the Erlanger case, where the executive talked about how they were going to profit from adding physicians because they're going to get all their referrals, that's actually not required in order to maintain, a False Claims Act premised on the Stark Law. It's a strict liability statute. There's some knowledge elements in there that you got to deal with, but in general, it's a scary enforcement landscape when you're talking about Stark, and you're seeing an uptick in Stark enforcement. You're seeing a big Indiana settlement earlier this year, record-breaking settlement. You're seeing this big Erlanger False Claims Act complaint. I think you've got to be very mindful of how you're doing your valuations, how you're handling business realities, And so this is something that we're going to continue to focus on in the podcast and other thought leadership for Husch Blackwell. If you're in-house somewhere with a physician group or a health system, life sciences company, make sure you're staying on top of this. We'd love to be your source for getting you that thought leadership. So continue to monitor our writings, continue to listen to the podcast, because this is a serious time from an enforcement landscape, and we're here to guide you through it. So again, thanks to Hal for being our guest, and we will see you next time.
Thank you. Well, Jonathan, you're amazing, and you're providing a great service to everybody.
Thanks, Hal.